Fine student, today we are going to cover a very important topic, that is Banking Laws Amendment Bill 2024. And yes, we are going to learn some basic features of this bill. And this bill has been passed from the Lok Sabha, and right now this bill is in Rajya Sabha. And we hope this bill will be passed because it carries some good changes actually. So basically this bill, before that I would like to say that these topics you can relate from GS paper 3 economic development. Okay, fine. So from a layman perspective, you should try to understand what type of changes does this bill brings. Number one, and first I would like to say about the minor changes. We know we have RBI Act 1934. It will bring some minor changes in RBI Act 1934. It will bring some minor changes in SBI Act 1955 also. It will bring some minor changes in 1970 Nationalization Banks Act also. It will bring some minor changes in Nationalization Act of 1980 also. But it will bring major changes in your Banking Regulation Act 1949. It will bring major changes in Banking Regulation Act 1949. That's why the name of the bill is, what is the name of this bill? Banking Laws Bill 2024. Because it replaced, or you can say it brings a lot of major changes of Act of 1949. Fine, but however it brings lot of minor changes in SBI Act, RBI Act, fine, 1917 Act of Banking Nationalization and 1980 Act of Banking Nationalization. Fine, so let's see. Lok Sabha has already passed your Banking Laws Bill 2024 and it proposes 19 changes, 19 amendments to banking laws, including minor changes in your RBI Act 1934, correct? Banking Regulation Act of 1949, major changes in Banking Regulation Act 1949, as State Bank of India SBI Act 1955, and Banking Company Acts of 1970 and 1980. The Banking Companies Act is same, that is a nationalization of banking in 1970 and 1980. In Banking Companies Act is the same of that of 1970 and 1980. Fine? Yes. Why we required such type of thing this time? So as per Finance Minister, she said that this amendment will strengthen the governance in the banking sector and it will bring some certain changes that are very, very important in present situation. Fine, these amendments reflect an effort to align the regulatory. We need some good framework in order to cope with the contemporary practices, economic realities and existing legal frameworks. So in order to cope the present situation, we require such amendments. Yes, what type of things, what type of amendments we expect from this bill are, number one, yes, till now there is a concept of nominee and there is only a one nominee, and if anyone open account, there is a concept of nominee. If I open account, so I have to fill up name of my nominee also. It can be my blood relation, it can be from my blood relation, it can be my brother, it can be my friends also. Only one nominee. For opening the account also, saving account, current account, everything. And for locker account also. Locker account, you know, whatever you have, like gold, money, you can keep in the locker. And for that you will get key. That is a locker account. And RBI and bank will take some charges for that. Because banks are actually, they are showing themselves as a custodian. Actually, they are presenting them as a custodian. For that you have to give some extra amount. That's a locker account. So whether a account or locker account, whether a simple account or locker account, there is only a concept of one nominee. But take a situation. Let's say nominee of husband is wife and nominee of wife is husband, and both are traveling on a road, and suddenly accidents happens. Then who will claim the money? Big problem, no? That time unclaimed money will go to the dedicated fund. If money is not claimed for 7 years, that money will go to the some education and some fund. So it's a very pathetic situation, no? That's why government decided to increase nominee from 1 to 4. And this time nominee can be in the form of simultaneous or it can be in the form of successive. What is the meaning of simultaneous nominees and what is the meaning of successive nominees? First we look simultaneous nominees. Simultaneous nominee, let's say 4 are nominated. A, B, C and D are nominated because there is concept of 4 nominees from now onwards for your every account, for locker account or your simple account or bank account. So if you are talking about the successive, simultaneous nominees, let's say if anyone dies, there are 4 nominees, fine. First nominee may get 20% share. Second nominee may get 30% share. Fourth nominee may get 80, let's say 50% share, and the rest will get the rest share. Fine. This is called simultaneous nominee. And what is the meaning of successive nominee? Successive nominee is that, let's say I nominated 4 nominees. If 4 nominees A, B, C and D, I am talking about the successive nominee, concept of successive nominee. If I die, on my behalf A will come and A will get every money, everything, whatever money I have in my account will get will deliver to the A person. If A will not come forward, B will come. If B will not come, if B will not want to come forward, then C will come. If C will not come, D will come. In this way, there are a lot of options. No, there are a lot of options of nominees, and at least that money will not go to the dedicated fund. That's why government has brought such a big changes in the form of either successive nominee or simultaneous nominee, and from now onwards the nominee increases from 1 to 4. Yes, first slide. At present, bank deposit can have only 1 nominee for their bank accounts. Fine. Now the bill enables the depositor to nominate up to 4 individuals for their bank account or fixed account, simple account, saving account or current account. There is also provision for simultaneous and successive nomination for deposit. I told you, no, what is the meaning of successive nomination and what is the meaning of simultaneous nomination. For other purpose like locker, for the locker, you just see for a bank account or fixed deposit, there can be simultaneous and successive nomination. But so far locker account is concerned, there must be only your successive nomination. If A will not come, B will come. If B will not come, C will come. There is no concept of share 20%, 30%, 40% like of simultaneous nomination. So for locker account, there will be concept of only successive nomination. It is expected to enhance customer convenience and address the unclaimed deposit issues. Because till now, what we have seen, till now, if anyone is not coming forward to claim the money for 7 years, then money will go to the dedicated fund. But this time, if there is a concept of 4 nominees, automatically 1 will come. And at the same time, we are seeing the problems like if I nominate a member who is not in my blood relation, if I die, then my blood relation member come and they claim. So lots of pending cases, litigation are happening in the lower courts. So in order to reduce the litigation also, central government wants to bring such change. Unclaimed deposit with bank stand, you see just how much money are at the fund, 78,000 crore at the end of March 2024. Just you can relate how much money are in the fund, and no one is claiming because of the faulty nominee concept, only 1 nominee. So changes in nomination mechanism offers flexibility to depositor and avoids dispute and litigation which usually occur after the death of the depositor. Fine. So yes, second one, very important. Second one, redefining the concept of substantial interest. What is the meaning of substantial interest? Means interest of much bigger degree actually. Let's say director, okay, fine, director or managing director you can say. Previously there was a concept that if director holds 5 lakhs share, if a person I'm giving you example, simple example. If a person holding 5 lakh rupees in a bank, he will not become director. What is rubbish? Holding a 5 lakh is not a big amount. If let's say I hold 5 lakh rupees in a one bank, let's say State Bank of India, and I am capable to become a manager, but I am not going to become manager because why? Because 5 lakh money I hold in the SBI account, in that same branch. So RBI actually, our government increases this amount from 5 lakh to the 2 crore. If anyone holds 2 crore money, in any bank, that time he will not become director. Otherwise, he will become director. It's a very good step actually, because for the past 6 decades, the concept of 5 lakh remains same. You just see the irony. Holding a 5 lakh money is not a big event. It's a not big thing, no, present time, because people is having lot of money. And merely having 5 lakh money in a one account, how can it deter me to become a director of that bank? So it must increase the threshold. So government decided to increase the threshold from 5 lakh to the 2 crore. If anyone holds 2 crore or more than 2 crores in any account or in any bank, that time he will not become the director of that bank. So that's why the bill redefines the substantial interest for bank directorship by raising the threshold from 5 lakh to 2 crore. And this 5 lakh, you just see, your 5 lakh remain unchanged for nearly 6 decades. It could have changed, no? Previous government could have changed this threshold. The redefinition of substantial interest threshold represents significant advance in, because now the thing is very changed. Having 5 lakh in any account is not a big deal nowadays. Even a middle class people have 5 lakh or 10 lakh rupees in one account. So the increase in the directorships threshold are in line with the current economic realities. Fine. So this is a second very, very important step. It increases from a threshold of 5 lakh to the 2 crore. Fine. For the directors, who want to become a directors, he should not hold money above 2 crore rupees. It must be below the 2 crore rupees. Last one, third one, is very, very important. Very, very important. Tenure of directors. Tenure of director or chairman or whole-time directors. Right now, the tenure, length of the serving period is 8 years. It increased from 8 to 10 years. Now, a director can remain in the office for the 10 years. Because at least we have to give some space, because in 2, 3, 4, 5, 6 years, we are getting experience. At least use experience for the 10 years, no? So that's why government decided to increase the tenure of director from 8 years to the 10 years. And it is a very par with the 97th Constitutional Amendment Act 2011. We have seen, no, 2011 Act, 97th Constitutional Amendment Act. That act was brought for the cooperative society, and it brought a major change in Article 19, and it brought a new article in DPSP also. We have seen, no, we have seen these things. The bill, first thing is that, yes, now chairman and whole-time director can sit in their office 10 years, up to 10 years, fine. And it is a par with the 97th Constitutional Amendment Act 2011. The second change is that now the director of Central Cooperative Bank can become the director of State Cooperative Bank also. You'll ask me, sir, then what is the changes? Previously, listen carefully, previously RBI appoints the director of State Cooperative Bank. Fine, State Cooperative Bank. But this time, if there is a director at district level, if there is a director of Central Cooperative Bank at the district level, he can be promoted to become the director of State Cooperative Bank. This is the first time this is happening in our country. The usual convention was or has been that State Cooperative, the director of State Cooperative Bank will appoint from the RBI. But now this time, the Central Cooperative Bank at the district level the director of Central Cooperative Bank at district level can be promoted to become the director of State Cooperative Bank. That is the changes this act brought, or this bill has brought. Number third, yes, very important thing. We know that public sector banks are very lethargic, especially in auditing process. And private banks are very known for the good auditing skills, because private banks always hire some good professional auditors. So that's why the government has made an amendment, and government has said that even public sector banks also can hire professional auditor from outside, and public bank will decide how much money they want to give to the professional auditors. Because what will happen with this, the auditing power of the public sector bank also increases, because we require auditing power. How much money has gone, where, how much monies are left, what is the condition of banking seed? For that we require a very good professionals. That's why the bill also seeks to give greater freedom to the banks in deciding the remuneration to be paid to the statutory auditor. Means banks can hire the professional auditors, like the private banks have full flexibility to hire professional auditors. Because if the public sector banks will do the same thing which he did in the past, it will impact on the auditing power of the banking system. So in order to have good auditing power, the bank should have full flexibility to hire the outsiders, so that outsider will give the correct way of auditing process. Yes. And yes, we know that 97th Constitutional Amendment Act, yes, fine. So yes, this Constitutional Amendment Act 2011 brought a major change, that is a cooperative society was added in Article 19 Clause 1 Clause C, and from an Article 19 Clause 1 Clause C is all citizens shall have the right to form association, unions as well as cooperative society. Fine. This is a new thing added by the 97th Constitutional Amendment Act. There was a rights to form association or unions previously, but this time in 2011 with 97th Constitutional Amendment Act, it came with the new change, that is we can form cooperative society. At the same time, with this amendment added a new article in the form of 43B in the DPSP, that it is a duty of the state to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative society. So it is all about the society, and state should be in the position to promote society, cooperative society, in a professional manner, in a democratic manner. Okay, fine. So yes, I want to add something new to this one. We have seen a recent case in the Supreme Court. Supreme Court, by using the doctrine of severability, it struck some of the points, because central government brought a new law, and central government wants to actually dilute the power of state cooperative society also. But Supreme Court told to the center, you can bring any laws related to the multi-cooperative society, not to the society belong to a state, because we know that there can be a two cooperative society. One society can be within the state, and one society can be outside of the state also. If cooperative society belongs to two or more than two states, it means it becomes a multi-cooperative society. Then that time center will come, that time center will give some framework. But if it comes within a state, then state is within the state, then state will decide what type of reservation, what type of things should be organized within the cooperative society. Means if cooperative society present within the state will decide. If it presents in two or more than two states, then central government will decide. So by using the doctrine of civility, Supreme Court struck down many provisions. Fine. So yes, Part 11B added to the Constitution for a cooperative society. And yes, you can see Part 9B, it contains the very important provisions that how many maximum directors can be in each society, reservation for SC, ST women, and duration of the term of elected members, etc. And yes, as per the Supreme Court judgment, 9b is applicable only to the center but not to the state, because if any cooperative society belongs to a state, state will decide how many SC will represent at the board level, how many ST will represent at the board level, how many women will be available at the board level, state will decide. But if any cooperative society present in in 2 states or more than 2 states, then central government will decide. So in recent times, Supreme Court intervened in this thing, and Supreme Court categorically told to the center that don't apply 9b to the states. 9b is only applicable to the center in case of multi-cooperative society. Fine, that's it, completed.